there and taps his hands and you're just sitting there and he, sits there and rocks back and forth in the chair like in a big old another murderer or whatever he is convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other or both, and in orange.
Hello, everybody. Excited utterance here. My name's Hella. It's my second stream of the day. And don't mind me. I have been busy chatting with my guest, and she's amazing. Kathy from the InDieZone is here. And I swear she's like my twin from overseas. Love her, love her, love her. Without further ado.
Hi, Hella. How are you?
I'm so good.
And my sister from another mother, right?
I reckon. Kathy and I were so busy chatting about Sarah Boone backstage. Kathy actually feels the same way I do about Sarah Boone. Oh my goodness, she's going to have to come on my Sarah Boone streams. Unbelievable. But yes, we're talking about Kohberger today. And just as I imagined, Kathy is a wealth of knowledge when it comes to this case. Welcome, Kathy. Could you give us a little bit of background about yourself and how you got involved in this case?
Yes, of course. First off, thank you so much for your invitation. I love your introduction. Very great. I've always been interested, Hella, in true crime, going back probably to the 1990s. A friend of mine handed me one of Ann Rule's books. I don't know if you've ever heard of her, but she was a true crime writer who knew Ted Bundy back in the day. Hi, Audrey.
Hi, Audrey.
So I went to see her speak, and she spoke on the Bundy case. She spoke a few other cases, and I just became interested in true crime because, just interested in how it is that law enforcement goes about and investigates, and then when a perpetrator is caught, given that it is the correct person, which I do not believe is in the Kohberger case. I do not believe they have the correct person. How it is they investigate and what it is about the perpetrator, why the victims, their lives, why was it that someone would do something so horrendous to them? So I've been really interested in true crime for a very long time. And then I have a background in independent art, music, and I had this podcast channel which began with, looking at independent art and music and books and media especially. And so I started about 5 years ago on Spotify. For the past couple of years, it was sort of dead. And then I was introduced to the Kohberger case by my husband. He told me about this case about a year and a half ago. And just then that was it, just started to research it. I knew that there was just something terribly wrong with the case. And I started to look at the PCA and, really looked at the PCA every page by page by page, saw that there was a lot of problems with that document. So I decided, I would do a podcast on that. And so I've decided now to do the entire docket. We're 100, almost 200 episodes right now.
Yeah, you're at like 189 or something like that.
Mm-hmm.
You've gotten even further than that now. What I love about your podcast, and there's so many things about your podcast that I love, but I love how digestible it is. You can just click on one of them. They're under 5 minutes per episode. So it's not like you are listening to a really long session every time. You can click on one, 5 minutes, and then you're like, okay, next, okay, next, okay, next. So I think that format, like some people like really long format podcasts, but I love the fact that I can just get a little bit and understand where you're coming from, and then if I want to invest more time, I can. But yeah, I've never really experienced podcast format like that before, and I really appreciate it. So I think, yeah. Excellent. Kathy, straight out of the gate with a hot take. Yes, absolutely. Good to see you again, genitals. Love you, genitals. Genitals. That's the funniest name on the internet.
I love it.
All right. And who else did I want to say hello to here? Diane. Diane. Hey, Diane. Good to see you. It's 3 a.m. for you.
Diane.
You're in Europe, aren't you? I will definitely. I've actually asked Diane to come on one of these episodes as well at some point. So this is an ongoing series, and Kathy's my first guest. And definitely, I would like to have Diane too. And I've also noticed there's somebody else here in chat. Who is it? Audrey. Audrey's got her own channel, and Audrey does some work with. You work in the lab, don't you? Are you DNA? You work with DNA. She's been doing some excellent takes on the DNA evidence in this case. So I'm interested to talk to you too, Audrey. Anyway, let's get into it. So, documents. You are the expert on the documents, Kathy, and there's a lot of documents in this case. And the other cool thing is this stream is dropping just in time because we've had a response from the state on the big one, the change of venue. The change of venue. Last time I did a long stream on Kohberger, it was the motion for change of venue from about 3 weeks ago, the 319-page one. However, you've pointed out to me something that I'd forgotten about or didn't know about, and that is that the first motion for change of venue happened in January this year. So we're going to bring that one up first. And can you talk me through this, please, Kathy?
I would be delighted to. Well, we always kind of knew, I think, in the back of our minds that Ann Taylor, who was, I think, a brilliant attorney, would be seeking to change the venue. I think that she really needed to, just because of all of the pretrial publicity and everything else that was going on in the case. You sort of got little nuggets, and that's the beauty of looking at the documents as we go along, because there's so much information that is behind the scenes that's under seal. But if you look at the documents all along, you can get some tips. And yeah, we got the big document drop recently, which was the large hundreds of pages that Ann Taylor did. But preceding that, the first time that Mr. Kohberger indicated formally that he would be seeking to change the venue was with this document, as you've indicated, Hala, that was dropped on January 30th, 2024. This is almost 9 months ago now. And just like procedurally, what's a motion? What's a response? What's a reply? A motion is an application for a court order. So you'll have one of the parties, the moving party. In this case, it's Bryan Kohberger, who is coming forward by and through his attorneys, and he's filing a motion to change the venue. What this means is he wants one of two things. He either wants a jury from another county to come into Laton, this tiny, tiny courthouse that really can't support a trial of this magnitude, or he wants he wants the jury trial moved to another county. So one of my listeners had asked me, Kathy, why didn't they look to move it to Texas or somewhere else, California, get out of Idaho? They can't, because this is a state case. This is a state case.
Different laws.
Right, Hella. You get it, right? These are not federal charges. So the best they can do is seek to move it to another county within the state of Idaho. And we see the first, what jumped out on the page at me here is, he says here, comes now Bryan C. Kohberger. As always, you have to come buying through your attorneys, and moves the court for which he's really asking for, is a motion, an order changing venue. By this motion, notice how they humanize him. They call him Bryan. Kohberger. Bryan requests a jury pool from with outside. So when I saw this, I said, okay, like we've had situations where they bring in a jury panel from another county and they bring it into the county. So I thought, wow, are they looking for a jury pool for another one to come into Latah? But I think she made it clear with the document drop of a couple of weeks ago that you talked about, that what they want is they vent the venue. So he's requested a jury pool from outside Latah County. Now, Latah County, why Latah County? It's because that's where the crimes happened. The jurisdiction is the county. Moscow Police Department, it's their jurisdiction. They are the lead agency. He goes into stating, this motion is made pursuant to, he's got to cite to legal authority that allows you, just go in there and say, hey, Judge John, I don't like it here in Moscow. I want to go to Ada. You can't just do that. You have to show legal authority. You will notice always that he starts with, Ann Taylor, and this is her brilliance, she starts with federal law first. Even though this is a state case, federal law supersedes. That's the supremacy clause. It's Article 3 of the United States Constitution. So she says, Fifth Amendment, that is his right to an attorney. You have a right to counsel. And we've seen Ann Taylor stand up in court and say, I need to do this because I wouldn't be representing, I would be ineffective at counsel. Fifth Amendment. The big one is the Sixth Amendment. That's right to a fair trial. Every criminal defendant in the United States, this is the Sixth Amendment Bill of Rights, has a right to a fair and an impartial jury of their peers. So she cites to the 14th Amendment is the due process clause. That means that the states have got to give you due process of law, can't take away your life, can't take away your liberty or your property without fairly giving you, fair trial, impartial judiciary, and notice, opportunity to be heard. So she cites to the United States Constitution. Then she cites to, secondly, you will always see her doing this. Then she goes to the state law, state constitution, and the rules of procedure. I think one of the other podcasters was saying, oh God, this is so long, all of this, but they have to recite to Judge and explain to him. So this is the legal authority. Now she has to cite facts that give the court the teeth. Okay, so here I've cited the legal authority. Now, what now gives me the right to come to the judge, asking him to enter an order changing venue? And this is where page 2, then she goes through the reasons. So you see here, Sixth Amendment, right away, a fair and an impartial jury, Sixth Amendment due process cannot be found in Latah County, she's saying. Owing to the extensive inflammatory pretrial publicity, allegations made by Mr. Kohberger to the public by media that will be inadmissible at trial. This is a key point, because a lot of what the media, the mainstream media especially, they come up with all sorts. He's a cannibal. He was an incel. He was this. He was that. All of that is inflammatory. It is not admissible. You need to have facts. It needs to be relevant. It needs to be admissible in a trial context. So she's saying here that there has been so much, the avalanche of negative publicity against him has been incredible. They deemed him guilty the day of his arrest.
Absolutely. No question.
How did you find that as well? Because I know you've been following this case so
Oh,
close.
yes. I mean, and from over here, I mean, I'm in Australia, for goodness sake. And you can tell even from global publicity, it's if it's so obvious from over here how much he's been painted as a guilty man, how much must it be obvious if you are actually living in that area? So it has to be exponential, really. And if you then go and look at the more recent document and see some of the like the press releases, etc., they don't even come close to what's been floating around in social media, for example. So if you look at some of the larger podcasts and documentaries, your 48 Hours and your 2020s and your Nancy Grace, etc., it's just people just take this stuff for granted. They throw this stuff around like it's fact, and it's they don't think even twice about it. This latest book, this Howard Bloom book,
Oh,
what is that?
I don't know why he put that out. You know, I mean, I think
Money.
well, it's the green, isn't it? That's what it comes to.
Absolutely. But yeah, I mean, it drives me bonkers that this
Right.
kind of stuff is allowed to be thrown around out there, and it's so prejudicial and
It is.
it's so widespread that someone on the other side of the world can be hammered with this information.
Mhm.
All I have to do is search Idaho 4. That's all I have to do. If I'm interested at all in this case, I just
Yeah.
type those words in and I'm bombarded with this information. Now, if I were to live in that area, I wouldn't even have to search it. It would just be because I live in that area that it would
Right.
come at me, because that's how searches work. That's how the news feeds work. They look for your location.
Right.
So I wouldn't need to search. It would just come at me because I live in Brisbane, Australia. So therefore, things that relate to local area, just it appears in my search because it looks for my location. Simple. These people don't need to do anything for this information to come into their news cycle.
Right, and that's
Yeah.
that's the issue here. You know, it says here, she says here, allegations made about Mr. Kohberger into the public by the media that will be inadmissible at his trial. The small size of the community, this community, I looked up statistics today, you know, just to be prepared for tonight, 40,000 people. That is a
Yeah.
small town. The
That's
jury
very small.
pool, right now, you eliminate the people under the age of 18, the people that are not registered voters, the people who can't vote, and maybe you're down to, you know, 28,000 or 30,000 people. So she's saying this is not millions of people. It's not New York City. It's not Los Angeles. We have a large jury pool where you can go through voir dire and you can start eliminating people that are obviously biased and prejudiced. This is what, you know, not to jump ahead, but this is what the prosecutor is saying. Voir dire, we can go through it, which is absolutely false. But I'll give you my thoughts on that later. The small size of the community, that is a big issue because it tells you there is only a limited number of registered voters. And then he talks about she says here, enlarging the jury pool will not do anything to overcome this pervasive prejudicial publicity because Latah County does not have a large enough population center to avoid the bias in the community. And then she makes a critical point here. Further, the size of the community and the interconnectedness of its citizenry is problematic.
Yes.
The interconnected, everything focused. The elephant in the room here is the University of Idaho. Everyone is connected. If the University of Idaho closed tomorrow, Moscow would collapse economically. Everyone goes to that. Judge, 21. Oh, wow. That's even less than I thought. Thank you, CH. 20,000 hella. That is nothing.
That's so few.
For a trial of this
Like
magnitude.
a country town. I mean, but it's in terms of, I don't know geographically its size. I think it's a fairly small area as well. It's not rural, is it? But yeah, I mean, I suppose people go there to go to the university, isn't it? That's the main thing there, right?
That's the main economic base. If that university, let's say if it were to close tomorrow, there is nothing there to replace it. Everything depends on that university. The house rentals, the restaurants, the Walmart, the gas stations, the number of cops that MPD can hire. They get paid to go and to have 25%. Wow, I didn't know that.
This is so important. What's the 8%?
I agree.
Look at that. 25% have connection to the university. 22% have connection to law enforcement. These may overlap. Wow.
That is 1 in 4 people. Okay, have connections. Judge went to the University of Idaho. The prosecutor, Mr. Thompson, went to the university. Every cop that you see there, Corbin Smith, one of the first 3, he went to the University of Idaho. They all went to the University of Idaho. And you're talking about 4 students who attended the University of Idaho that were murdered. And this happened steps away from the University of Idaho. Sigma Chi, as we learned in the affidavit of probable cause, is on the campus. That frat house is on the campus. So, the interconnectedness is one thing that Bill Thompson did not talk about in his response yesterday. He didn't.
No.
I think that's, what do you think, Hella? I think that's.
I absolutely agree. And when we get to that response, there's other things that weren't addressed. But you can cut up statistics lots of ways. You can always look at them in any way in order to shape your opinion. And the same could probably be said backwards about the defense's submission of the survey results. But it kind of doesn't matter, because it's more important that this man gets a fair trial than not.
Exactly.
Right?
Exactly. Yeah. And, I think we were talking about this the other day, just back and forth, that remember when the trial was they were pushing for the trial to be in June 2024, which is ridiculous. I mean, June 2023.
That was ridiculous.
That was 6 months afterwards. And, murder, death penalty cases take years to come to trial.
They take years.
They take years. And the issue was, I could not believe, and again, I give my opinion as I do as a broad podcaster and citizen under the First Amendment, but I could not believe that Bill Thompson stood up in open court and said that we need to have this trial in the summer to accommodate the high school traffic. Looking at a 28-year-old man here whose life's on the line. We have this murder trial for 4 people, 4 young people and we're going to focus everything on whether hotels can accommodate out-of-town guests and whether the high school is not. I said, when I covered that in my podcast episode, I said, who made the brilliant decision to put that high school right there? It should have never been next to a jail and a courthouse.
Oh my God. Okay. Now I'm having flashbacks, because I remember now this motion. And it went to a hearing. I actually streamed it.
You did?
Okay. I did, because I remember at the hearing they were talking about parking.
Yes.
Yes. Now, yeah, I'm having flashback now, because I had 2 lawyers on stream actually with me, and I also had Mo from Mo in the Deep, and she was making jokes about the fact that the biggest issue was parking. Why are we all standing around talking about parking?
Right.
Unbelievable.
You have a situation here where a young man's life is at stake. It's life, liberty, or property. That's the due process clause. His life is at stake. His liberty's been taken away.
Unbelievable.
30th.
That's right. And because it was taken off the table for quite a while, they were like, we'll just put off this motion for change of venue for later. And of course, it came back up later. Online Red says this is why they went to Ada for the Daybell trials, and Rexburg, Madison County is bigger than Moscow later. Much bigger, much. And so you've got a greater amount of people to choose from who are far less invested in the case.
Right.
It
right.
makes sense, doesn't it?
Or that know someone from the university, knew one of the students, firsthand. I mean, it's just, this is what she's talking about. I think this is one of the things that I hope that he will grant this motion. I have to say I have some concerns, because he will then have to say that his home county where he has lived, he was an attorney before he became a judge in Moscow. He had his law offices. He's going to have to make a decision that the people of Latah County are biased, and I that will take just a lot of fortitude for him to make that ruling, and that's my fear. He's
elected there, right?
I'm not sure if he's elected or if he was appointed by, like, the governor will appoint judges or
that's an interesting question.
But that's a good point, because if he's up for re-election, it will be even tougher for him. I just imagine him walking down the Moscow Walmart, getting ice cream or something, and some of the women just kind of, oh boy, judge, we're biased, we're prejudiced.
He sold us out. Yeah,
you sold us out. We could have done here. So he, and speaking of Bloom, going back, and I hate to bring him up, but he made a point that church, Christ Church, apparently the head of Christ Church told his congregation, because they don't like the Moscow Police Department because of what had happened with a few things. There's some bad history. Whatever the Moscow, when a cop is on the stand, Bloom reported, assume he's lying, because the Moscow Police Department lies. Excuse me.
Oh, well, they're allowed to lie, right? Yeah, of course they are. CH says, so happy Kathy is highlighting this, because Bill intentionally avoided the biggest issue, that the community is so connected and have personal connection to it. Yes.
Thank you.
Absolutely.
Yeah. Nancy Taylor right here. There she is. I mean, she's saying, and then it goes on to say.
Sorry, just one moment. Murph's turf. No, he has not ruled on this. The hearing is on the 30th of August, I believe. So yeah, that's right. The next hearing is scheduled for the 30th of August. So hopefully we will hear about it then.
Yeah,
we're waiting.
Point. They'll argue at that point.
Do go on, Kathy. Sorry.
No, that's okay. Yeah, we have the hearing come, and I'm glad that you brought that up, because it's procedurally what happened. So she's filed this motion. She says here, though, Mr. Kohberger, by and through his counsel, requests an opportunity to be heard. That's due process. Due process is the 14th Amendment. It's notice of hearing, opportunity to be heard in an impartial judiciary. That's federal. That's when they raise the 14th Amendment. That's what that relates to. So she's saying here she wants an opportunity to be heard, public hearing, through evidentiary presentation. So she's saying here, this is not something that we can argue legally. Like other motions, you'll see them arguing. They'll go back and forth as to, with the IGG, is it discoverable? Is it not discoverable? Here, you absolutely need evidentiary presentation, and this is where the witnesses that come into the expert witnesses come into play. And argument doesn't mean they're screaming at each other. Argument means she does her assertions. Thompson comes back no sooner than the end of April 2024. So she's telling the court January 30th, 2024. She wants this trial moved.
Yes. Okay. So that was back then, and then it didn't rest per se. She went along and got some surveys done, which really annoyed certain people. If we recall, there were some fiery motion hearings in between, or status hearings in between, where Mr. Bill Thompson got quite annoyed at defense And the judge actually got quite annoyed as well because he was sort of blindsided by the fact that this all happened, and it was all a little bit amusing, really.
Wasn't that hearing amazing when he stood up and said, I mean, Mr. Kohberger certainly got a nice Easter egg from that, because he stood up and he told Edelman, he told the doctor, now, Dr. Edelman, you realize that there's no evidence that Mr. Kohberger was ever stalking any of the victims. Okay, yes. So that was a nice, okay, so Mr. Kohberger got a nice point there.
That was very good.
Although some of mainstream media are still saying that he stalked the victims, unfortunately. And then, of course, I know Audrey is here as she was, and she has done an amazing job of capturing that point with remember the PowerPoint, how Bill Thompson got it. No, this PowerPoint, it's prejudiced. I just got it. He knew well what was coming. And then he said, where was all of this coming from? There you see Bill Thompson. Remember, he's standing up there. Now, we want you to distribute the PCA to everybody. That was the 30th hearing, right?
Who was it who said to distribute this widely?
Who was it?
That would be you. That would be you, Mr. Thompson. You said to distribute it widely. Well, how many facts in the PCA have since been debugged? Just about most of them. Quite a lot.
No, you can't even begin. I don't know how this is a big sore point for me, because this was the reason why I started the InDieZone. It was to go through the PCA. It was going to be an 18 episode series, and then I was going to go back to doing music or art or something else, by page. And when you look at it page by page, line by line, first of all, he never puts Bryan Kohberger in the house, ever. He makes you think. This is what, it's a lot of creative writing in it. The timeline is 4 o'clock to 4:25 a.m., but suspect one is still seen driving around at 4:04, and he's seen speeding out of the neighborhood at 4:20. I don't know how Megan Marshall signed off on that affidavit and entered the warrant for his arrest. She did. I mean, I had to go to a judge, and that was Judge Marshall, who did all of the errors, all of the things that make no sense. There's the facts. It needs to be pristine. He had typographical errors. He's calling Mr. Kohberger. The phone was critical. The phone pings and the cast data. At one point, he's calling his phone, the last 4 digits, the 8458 phone. He's calling it out in other places, the 8458 phone. He's like interchanging the numbers. He's calling him Bryan Kohberger. He's changing DM's testimony. He's saying, well, DM, she said that, he was page 4 of the PCA. DM heard what she thought she heard coming from the 3rd floor. Kaylee's saying, I think there's someone here. Well, what he does in the PCA is, well, that also could have been Xana. It's like, first off, what are you doing changing a witness's testimony?
Make your mind up. Also, this whole white Elantra thing drives me berserk. Like a white sedan. How hard is it to decide that a white sedan belongs to somebody when you've got no plates and some blurry CCTV, and you're basing your whole timeline on some pings that only the way a ping works is it goes like that. So it can be anywhere in that area. So you're basing your timeline on some CCTV of perhaps a car that kind of resembles him and some pings that are in this kind of area. And you're saying that car and a ping in this kind of area is him, right? And it's just like, it is not just like throwing a dart at a wall.
I think they were under pressure. And then if you look also, I mean, again, this is my opinion only. They arrested him December 30th, 2022. That was days before the University of Idaho was going to open up again for the spring semester. So it's sort of like, okay, everyone, students, families, parents, you can send your kids back, come back to Moscow, spend your money. The boy is in jail now. Yeah, if you look at that interview, they did after he was arrested in Monroe County, Pennsylvania, they did the press conference, and you see Thompson at the podium, and it's like Green, University President Green, is literally over his shoulder. And it was such a powerful image. There were, he put out a book, and I have not read this book. I'm getting this secondhand, but some people are saying that the U of I representatives were in meetings with law enforcement when they were having, I was like, what is the University of I? What are they doing in those meetings when the FBI?
Yes, why? They have a vested interest.
Right.
They shouldn't be there.
Should not be there, but that's why we say that seems to be the elephant in the room.
There's many elephants in the room.
Anyway, the state gave the defense the video, of the 2011-13.
Yeah. And that's another huge one, the fact that he didn't even have a 2011 to 2013 Elantra. And so they changed the description of it to a 2015 that he had, or 2016, a later model. Once they decided it was him, they were like, "Oh no, it was actually a later one. That's fine."
Well, you bring up such a critically important point regarding suspect vehicle 1, and I do urge anyone who has a real interest in this case, if you haven't read the PCA in a while, go back and read it. Because the three things that got this guy arrested, whether or not they say, "Oh, we're not going to use the sheath," in to arrest him as a basis. Nonsense. It was the sheath. It was he was the driver of suspect vehicle 1, and it was the phone pings. That's it. They don't have his blood in that house. You would think, given the nature
everywhere
of crimes, that his DNA, sweat, tears, blood, fingerprints, skin, cuts would be all over that, and that he would have taken it with him in his Elantra, in his car, in his home in Pennsylvania. He would have taken his DNA. Doesn't people say, "Oh, well, he got this Dickies out"? Like, DNA doesn't work like that. Doesn't work as a repellent. It's not like it's kryptonite against DNA. DNA gets all over, right? Yeah. So those were the three things. What got me really concerned about this case, my son had said, "Mom, they put out a bolo, the be on the lookout." Well, they're supposedly, if you look at the PCA, he goes on for pages about suspect vehicle 1, where it's at. They have all this video, they have all this imagery. It's making a 3-point turn, it's trying to park, it's doing this. The Moscow Police Department never released an official image of suspect vehicle 1. We have seen what we think might be Linda Lane, maybe, or at the gas station, but MPD never released. And for them not to release an official image of this car in the Bolo, I have to ask, why? Why are they putting in 2 stock images, one of a car with a sunroof? We've seen Mr. Kohberger's car. It doesn't have a sunroof.
Doesn't have a sunroof, no.
So why hide the car? The car's everything. Why hide? And like you said, then they changed it from it. It was originally, it was 2011 to 13, and then it could be also, on second thought, the FBI specialist, 2011.
It might be a later one.
It might be, Alan, if he drove a 2021, it might be a 2011 to a 2021 Hyundai Elantra. But the idea that they never released an official photograph of suspect vehicle 1, including in the Bolo, just began, I started to say, there's something wrong here. There is something wrong with this case.
Oh, look, the first thing that tipped me off was that he didn't leave any of himself there, and also that there was no sign of cleanup in his car, in his apartment, nothing. Like, those of us here who are familiar with this channel, and been hanging around our sort of circle for a long time, we are advocates for someone who's been unfortunately convicted already, wrongfully, and his name's Zachariah Anderson, and Zachariah Anderson was convicted of a crime, convicted of first-degree murder and hiding a body based on 1 pinprick of touch DNA.
Wow. Touch.
Yes.
Touch is just, They found that and then there's questions about, if you look at the PCA and you read the PCA, he arrives at 4:00 with Sergeant Blacker. We have the arrival of Brett Payne, who is the lead detective. He's going to be the author of the PCA. He arrives at 4 p.m. These crimes happened, according to Moscow Police Department, between 4 and 4:25 a.m. So he's turned up at 4:00, and he is met by one of the first responders at the door, Corbin Smith, and they start to go through the house. They go up to the 3rd floor, and what I don't understand is how Officer Smith didn't say, "Oh, detective, you're not going to believe this. Now, I've just shown you 2 bodies on the 2nd floor. Here's the other 2, and look right there. There's a knife sheath on the bed." So it seems as though none of the first 3 responders who arrived at noon saw that knife sheath. It appears that Mr. Payne didn't. When he walked in, it was later found. So we see one of the
I'm
defendants.
so sus on this knife sheath. I'm so sus on this knife sheath. And anything that has like transfer, touch DNA on it, I'm so sus on it, because I have seen someone be wrongfully convicted with this. So it's just, yeah. And I'm looking forward to talking to Audrey about this, actually.
Yeah, she's a great resource on this information. Jay Lawson is with you. He in one of his filings, he said, and the sheath was placed on the bed.
Yes.
Placed. And then sometimes it's visible from the door, but then it's under a blanket, under Maddie. It's partially under Maddie. It's partially under a blanket. It's like this knife sheath moves. And so ISP, who was already there, the Idaho State Police, they're invited in by Moscow Police Department. They're already starting to begin processing the scene. When Payne and when Blacker arrive at 4 p.m., they apparently, from what we can tell here, is who found the sheath. So it's like, okay, so Blacker probably went up, I would imagine, went to the floors to Sergeant Blacker. Detective Payne, the 3 first, none of them, nobody from Moscow Police Department saw that sheath. Is that possible? You know, when Detective Payne arrived, he said that one of the first 3 officers, Officer Nunez, showed him his body cam, and that's how he saw Murphy, that there was a dog in Kaylee's room. By then, Murphy had been removed. Why isn't he showing him the body cam of the knife sheath? There's no mention of it, and that is such a critical issue. It's one of the 3 things that got arrested.
So CH says that is the biggest red flag. Blaker's description is so different to Payne's of the sheath when they do the walkthrough together. And then CH has gone, no, they weren't processing, Kathy. Read it again, paragraph 2.
They were setting up. They were setting up and getting ready to process at 4:00. ISP was already there, but they were setting up and they were getting ready to process. But that's when she's right. They hadn't already begun the processing. They were starting to get ready to process the scene.
Okay. We've never seen a photo of it, have we? This sheath.
We've seen nothing. I mean, that's the issue. And one of my sore points about this case.
Yeah, we don't get to see anything.
Number of all of the discovery is under seal. There's 52 gigabyte of all of this information. Are you telling me there's not one photograph of a stop sign at an intersection or a document that could be redacted to be released to the public? They've released nothing. Everything is under seal. So nope, we haven't seen the sheath. We haven't seen the car. We haven't seen any of the PCA talks about the evidence, but the PCA is not evidence.
We're all just supposed to believe it. In fact, people do. They just believe it.
Right.
They just believe it.
And they had him convicted from when that, it's a horrendous crime. It's like the defense counsel says here, this was a salacious crime. This was a horrible crime. It shocked the senses. And here you have a guy that's here that everyone's saying he's guilty. People believe it.
All right, let's move on to this document that dropped yesterday. And if you recall my previous stream, and that was the 319-page document from the defense. It was obviously a follow-up document to the one that we were just looking at back from January, and it
Mhm.
was by the defense, by Bryan Kohberger, obviously comes via his defense counsel, and it was for the change of venue, and it included Dr. Edelman's analysis of the survey of the jury pool in Latah County, and he also surveyed Ada County and one of the other ones nearby that he looked at. Do you remember?
Yes, he looked at 3 different counties, and that's a good point that I'd like to bring up. Yes, you're absolutely right. The last paragraph that Ann Taylor wrote in the January 30th, 2024 motion for change of venue is, we would like to have an opportunity to present evidence, and that's what evidence is.
Evidence is, yes.
Declarations, statements of expert witnesses, and what has, what I was shocked at, yes, I don't know if you want to pull up, is this, okay, here's the objection. The first thing that jumped out at me is that there is no counter expert testimony here at all.
No, there's not.
But I mean, this is Bill Thompson. He seems to think, in my opinion, again, that he is an expert on everything. He has not produced a single expert. We get a battle of the experts in trial.
Yeah.
Your expert says this. No, my expert says that. Look at all of the experts the defense have brought. We've Gabrielle Vargas and Cy Ray and Dr. Edelman and Barlow, and they've introduced a number of experts. I was very shocked, but not really, because Bill Thompson thinks he's going to be able to talk his way through everything.
Well, I mean, it's interesting you say that, because Bill Thompson is trying to, in this document, he's trying to make arguments that relate to market research. So you're right. Like, he's not a market researcher as far as I know.
Well, if you remember the infamous interview when he stood up and he said, "Hey, I go to Mexico, I go here, I get stopped about this case." And he said something like, the only town that hasn't heard about this case is Lewiston. Like, where are you getting? I mean, you do not do market research. That marketing is another field. You're an attorney, but he didn't have a DNA expert. He didn't bring up a cast expert or list to counter Cy Ray. He didn't even cross-examine them. What they did, Gabriella Vargas outside of court, she was approached. They admitted to that, but all of the documents telling us why they approached Gabriella Vargas outside of court is under seal.
Yeah, of course. All right, so the defendant filed a motion to change venue, requesting that the trial in this manner be moved from Latah County, where the offences took place, I have to put that down, to Ada County, some 300 miles away, which would be, obviously, very inconvenient for me, because I'd have to drive there every day.
Right. They're going to move it 3,000 miles away. That's what they really need to do. Is they need to move it.
Yeah, exactly. To support his motion, he conducted a survey of prospective jurors in Latah County, Ada County, Canyon County, and Bannock County. Oh, that's right. Those are the other two. But far from demonstrating that a Latah County jury pool has been uniquely subjected to utterly corrupted environment, as defendant argued in his brief, the data showed that pervasive and wide-ranging coverage of this case throughout the entire state of Idaho has led to high case recognition among survey respondents across all 4 surveyed counties. Okay. Wow. The court should decline defendant's invitation to pass and split hairs over an incomplete data set, to reverse engineer a transfer to Ada County, which, according to the defendant's own expert, has received the second highest amount of media coverage in the state, and where a statistically greater number, albeit slight, of the survey respondents familiar with the case believe defendant is guilty. What? A statistically greater number, albeit slight, of the survey respondents familiar with the case believe defendant is guilty.
It's how he's interpreted, and you notice how he's going for the kill right away, Helen. He's going for that emotional response from Latah County resident Judge John Judge. The corrupt. Our neighbors are corrupt. They can't think for themselves. Another point which would have really worked in their favor is if the crime scene was in Latah County still, but the house knocked down, because a lot of times the jurors want to walk through, or we want to have it. Okay, let's have it so that they can see how far DM was standing from clad in black guy, or can't do that anymore. So when they knocked down that house, I said that's a great argument in favor of moving the venue, because the house isn't there anymore. Yeah. Well, you can see the patch of land there.
Well, that's kind of interesting, because I know that the defense didn't have a problem with the house being knocked down. In fact, they were fine with it at the time, and people were like, well, why? Why is it okay for the house to be knocked down? And Andrea Burkhart, she's my favorite lawyer who's been following this case. She actually spoke up about this at the time, and she said, look, there's nothing in there. There's no point in it being there. A jury walkthrough is not going to make any difference. It's all been gutted, guys. Just let it go. It's cool, right? And I'm sure that Ann Taylor knows what she's doing, right? Let her do her job.
Absolutely. To me, I think that if anything, it works in favor of the defense.
Now we see it.
Prosecution.
Don't see it now, right?
Right. Prosecution. Here we see. Okay, judge. The jury might want to go into the house, and the house is in Moscow, in Latah County, not in Ada County, not in Canyon County. Gone, so that argument is gone. The argument usually is inconvenience the witnesses, but I mean, a lot of the witnesses are college students, and they don't necessarily live in Moscow. They come from Coeur d'Alene, or they come from Meridian, or they come from wherever. By the time this trial happens, probably a lot of the ones that were their friends, or that maybe were around the house or whatever at 12 noon when 911 finally arrived, they may not be in Moscow anymore. They may have graduated, moved on. It's the convenience of the Moscow Police Department. It's the convenience of Mr. Thompson, because you're right, he's going to have to pick up and leave and drive, whatever it is, 300 miles away, or if it's Canyon County, however many miles away that is. But it all comes back to what's going to win the day is the Sixth Amendment. And that's what she keeps arguing: fair and impartial jury trial. And the thing that you can't argue here is moving it up to wherever, Canyon County, or moving it to Ada. You don't have everybody and their mother connected to the University of Idaho there. That's a connectedness issue.
Yes. All right. So, argument. Although the government generally must prosecute an offence in the county where it occurred, a court may change venue in two limited circumstances. Okay, let's see what. And he's referring to some ICARs, ACRs, whatever they are. ICRs.
Notice the Sixth Amendment's not mentioned here. That's
no.
Today. That is the big argument, and he doesn't even argue that here.
No, he's referring to Idaho criminal rules, are they?
Those are and the statute. 1801 is a statute. Right. So first, a court must change venue to another county if the court is satisfied that a fair and impartial trial cannot be had in the county where the case is pending. Well, duh. See also the similar language in IC 19-1801. Second, a court may, but is not required to, change venue for the convenience of the parties and in the interest of justice. May, but not is required to, change venue for the convenience of the parties and in the interest of justice. In this case, defendant has asked the court to change venues on both bases. For the following reasons, the defendant has failed to show that either of these circumstances apply. I think that that is quite secondary, though. The defendant has asked the court to change almost 99% because of his right to a fair trial, not because of convenience. And he's not even citing to the Sixth Amendment to the United States. That's
he's not.
it trumps everything because of the supremacy clause. All of these rules and everything else, this is fine. But he's got to argue the fair trial issue. I mean, he brings it up every time and is misnumbered number 1, 2, 2, 3, 4. I think it's number 3. Right to a fair trial. He raises it then in his objection. Discovery is sealed.
Yes. Yes. If you listen to Kathy's podcasts, you bring this up a lot, don't you, Kathy? Because it comes up a lot.
It's every time. It's
every time.
Cut and paste job that they do. I think it's obvious, Hella. I mean, can it be that they misnumber every time?
They're just copying and pasting.
Right.
They're just copying and pasting. So they misnumber the reasons for their objection, or their it's in the motions to seal, isn't it?
It is. Yes, it is going to be in the motions to seal the responses, but also in other things. It will be one. How the government, how they investigate, their investigative procedures, privacy, and right to fair trial. He numbers it 1, 2, 3, and 4, and you're not supposed to. Every issue stands on its own. You don't use the issues that you used 5 times before for the 6th issue. But it's like Judge will get it, and he doesn't say, dude, why are you misnumbering this 1, 2, 3, 4? He just signs off on everything. He
does. He clearly is not reading it.
No, clearly.
Or certainly not proofreading it.
Oh, this is a Thompson? This is a motion to seal. Oh, okay.
Okay, so the TrueScope media report does not show the entire picture. However, Defense Exhibit C in the definition section of the TrueScope report is explained that the report does not take into account data from YouTube, private Facebook groups, podcasts, streaming services such as Netflix, HBO, Paramount Plus, or Hulu. In fact, the report does not take into account data that is not location specific at all. Given the ubiquity of blogs, podcasts, documentaries, and other internet or streaming media, it is difficult to gauge how including that data may have changed the TrueScope report. Additionally, as the court is aware, this type of media, video bloggers on YouTube, true crime podcasts, true crime documentaries, and TikTok videos is often the most inflammatory and prejudicial because it lacks the professional standards and safeguards of traditional media outlets.
Yes, like the Grace show. And, what he's doing here, I mean, they just continue to attack the independent. And I understand. I mean, there are some podcasters out there that I don't agree with, but I think a lot of them get it right, like your podcast, very fair and impartial. You're coming across, you're giving another side of things. Who has prejudiced this trial more are not the small amount of these independent podcasters. It's the multi-millions of
the big ones.
Right. The Nancy Grace show, and like you say, Dateline and
News Nation,
Banfield. Right. I mean, those combined millions upon millions upon millions of viewers, but he doesn't put one of them in here. Not one.
Yeah.
Again, here, if I could just interject, Helen, what he's doing here is arguing as an expert. An expert should be arguing as to what what he said, the video bloggers, the YouTube, the true crime podcast, and what they do and what the impact is on Mr. Kohberger's right for a fair trial. That Dateline episode, yeah.
Dr. Phil, yeah.
Dr. Phil, yes.
Right. This is. I wonder. It's funny that he's like this whole thing about him not being an expert. I wonder whether this is going to come up in the hearing. I doubt it.
Well, I mean, he just. I don't understand. It's not as though he prosecutes mass murderers, all the time. It's not like New York. It's not like this is Miami or Los Angeles, where the last murder was 2014 in Moscow. So he's trying to be the prosecutor. He's trying to be, a marketing expert. He's trying to be a DNA expert. You need experts to come in and to help to explain things to the court in that specialized area of expertise. I don't know. I mean, they got deep pockets. This is the state. They can go out and tax if they need to hire someone. I don't understand, why he doesn't have one expert. I think it is arrogance. I think that he thinks he can do all of this himself.
True. I mean, maybe he also doesn't want to look like he's the one dragging things out either.
Well, he is.
It's a little bit. He is the one dragging things out, but
look at how long it took them to turn over the IgG evidence. They should have been. I mean, the minute that October 25th order, very, very long, important order on the IgG discovery, begins with the FBI told local authorities, look at Bryan Kohberger from that family tree. He should have been anticipating from the minute that they created that family tree to say, look at Bryan Kohberger, that he would need to turn over that evidence to the defendant. This is December of 2022. They only just got this evidence January of 2024. They were looking.
Oh, I know. But people like us notice this stuff, right? Whereas most of the general public are just like, oh, Bryan Kohberger is stalling because he knows that he's going to get the death penalty. Right. That's just what's going on. I'm just going to flick forward a little bit. So erection of press table for reporters inside the bar is unprecedented. I find these little footnotes to be interesting because they tend to hide things in here. The erection of
there's critical information in some of these footnotes. I mean,
yeah, I know. The erection of a press table for reporters inside the bar is unprecedented. The bar of the court is reserved for counsel, providing them a safe space in which to keep papers and exhibits and to confer privately with client and co-counsel. It is designed to protect the witness and jury from any distractions, intrusions, or influences, and to permit bench discussions of the judge's rulings away from the hearing of the public and jury. Having assigned almost all of the available seats in the courtroom to the news media, the judge lost his ability to supervise that environment. The movement of the reporters in and out of the courtroom caused frequent confusion and disruption of the trial. Oh, goodness me.
This is so irrelevant. I mean,
this is completely irrelevant. Oh, that was Shepherd Court something or other. So that was a different case. It's nothing to do with it. So move it. So move it. Dear me.
It just he doesn't want to do it. I mean, I think he wants to keep it in Latah. I think he has a lot of pressure from people in Latah County who have voted him. They have voted him prosecutor for 30 years. I mean, he has a lot of influence in this county, Latah, Mr. Thompson.
All right. So this is the part I really want to talk about. So his response to the survey. His argument is that the survey was specious, I suppose. It was lacking information. You can't make judgments about the integrity of the potential impartiality of the Latah County jurors or potential jurors when you're lacking information. So he says the survey data provided by Dr. Edelman is inadequate to justify a change of venue. It is not reported how many individuals declined to take the survey, raising serious concerns about non-response bias. So a glaring omission in the data provided by Dr. Edelman is the lack of information about the number of individuals who were contacted but chose not to respond to the survey.
You know where he got
important.
You know where he got this from? He didn't get this. This is where an expert submitting an expert report.
There's no way he made this up. Yeah.
He got this from an article. He got this from okay. What does this have to do with? And we can't ask this article. Scott Heater. How does this impact? His Sixth Amendment constitutional art. You can't ask a person who wrote an article 6 years ago that he seemed to find that seemed to Mr. Thompson to be a good argument. This is where an expert, Hella, would have been important to be able to, okay, here's my report. This is why this information is important.
100%. And it's just an article. It's not like a peer-reviewed study.
Right. It's right. It's okay. I got a magazine right here. I'll pull out an article. I mean, it's not peer review. You can't certainly ask Mr. Keeter a follow-up question. So yes, you can be sure that Edelman is a big gun. I mean, he worked on some big trials. His curriculum vitae is impressive. All of the experts that the defense brought in are extraordinarily important. You know, they've done some good work.
Exactly. Okay, so we have Bill Thompson versus Dr. Edelman, right?
Bill Thompson versus Dr. Edelman, Cy Ray, Gabriela Vargas, Betta Barlow, and everybody else. I mean, that was the first. Hella, I said, where's his expert? Where's his counter expert to say that Dr. Edelman doesn't know what he's talking about? And this is what, there's nothing here. So you're right. He's going up against Dr. Edelman here.
Yeah. As of the authoring of the 2017 article, promulgated by Pew Research Center, telephone poll response rates stabilized at approximately 9% after years of decline. Blah, 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 blah. Okay, so what he's getting at is that people who are interested in a topic are more likely to join in on telephone surveys, and therefore, if they're more likely to join in on telephone surveys, then they're invested in the case. And if they're invested in the case, well, maybe they're more likely to say guilty, guilty, guilty.
Right. Possible. I mean, I don't know. I think that this is all fluff right here. I think this is a waste of space because, I mean, you know, this does not take the place of an expert. Period.
It doesn't. I mean, it kind of makes a little bit of sense, maybe, potentially, but you can't prove it.
Now, you need to have somebody up on the stand who's able to explain it in detail and then is subject to cross-examination by Ann Taylor. You know, then she could poke. She can't cross-examine a magazine article, you know, that Mr. decides to
absolutely.
Judge. I mean, he might have questions. Judges have questions when experts are on the stand.
If anyone is interested in study validity, I found a few today. Survey response rates, trends in validity assessment framework. Interesting, CH. I used to work in market research, and also I was a creative director in an ad agency for many years, and we worked with media buying agencies who had market research teams on hand, and they would do market research and bring it to us and present it with you know, the graphs and the qualitative research and the quantitative research, and they would explain their strategies kind of like Dr. Edelman has done here. So I'm not unfamiliar with it. And I get kind of what Bill Thompson is saying, and it's not unsound. However, I would say that Dr. Edelman would have that data.
Exactly.
He wouldn't have just not thought about this.
Well, what's interesting, Hella, is the next part, because now Ann Taylor will have its motion, response, reply. So she's going to have an opportunity, and she's done it long, to reply to this response. And I'm sure that we're going to see something, a declaration or an affidavit from Dr. Edelman countering everything that he's putting in here. You know, or she also has other experts that she's going to have at this next hearing as well. So I would imagine that in the reply brief, and when they do a reply, they can't go back and re-argue everything. They just have to, they're limited to responding to the response. So it'll be curious to see if we see a Dr. Edelman affidavit attached to the reply.
I think we will. Okay, this court does not have complete survey data and therefore cannot adequately compare data among the four surveyed counties. As defendant acknowledges, this high-profile quadruple homicide case has captured the attention of the community, blah, blah, blah. What's he trying to get at here?
Lewiston, according to him. He said Lewiston is the one place they didn't hear about this case.
Where? Lewis where? Sorry?
He said at the hearing, when he stood up and said that the deciding factor should be traffic, he also said that when he went to Mexico, people asked him about this case, and people ask him about this case everywhere. But he claims that Lewiston would be a place where no one's heard of this case. I'm like, what? Lewiston is like right there.
Well, do they live in a bubble?
Well, this is the Bill Thompson market research firm. That's
right. Okay. Sure. All right. So he heard that from some lady who lives under a rock there.
Who knows? Who knows?
Who knows? Okay, so an example of incomplete data provided from Canyon and Bannock counties is found on pages 50 to 51 of Dr. Edelman's declaration, where he reports that in Canyon County, approximately 90% of the jury eligible population there had read, seen, or heard about the case, and 51% followed the case somewhat or very closely. And then in Bannock County, approximately 84% of survey respondents recognized the case, some 14 percentage points lower than Latah County.
It's the thing is here, it doesn't matter. He's right. This is a high profile case. People have heard of it. It's the prejudice and it is the bias. In these other counties, they don't have Bill Thompson, who they have voted for 30 years prosecuting this case. They're not interrelated to the University of Idaho. So the fact that people have heard about the case, it's one thing.
Doesn't mean anything. Yeah, exactly. It's like heard of, know about it somewhat, big deal. Are you one of those people who said, if I got a not guilty verdict, I'm going to burn the courthouse down?
Right. No,
right.
I mean, everyone's heard about the case, unless you've got your head in the sand. I mean, you've heard, people have heard about this case. It's the bias that is the concern that Ann Taylor has, that she needs to meet, but by a proffering of evidence. And Dr. Edelman is a key part. 50 something page declaration. We know how long it took to put that declaration together. I mean, it has to be seen, every word, because he's testifying under penalty of perjury, much like the affidavit of probable cause. You're testifying under penalty of perjury. It has to be perfect.
And I have a feeling that someone who is a PhD in his field, going to court and putting forth his work, would take that quite seriously, which, as opposed to a DA who has something to lose from not getting a conviction.
He's worked on some high profile. I think the Oklahoma City bomber case, Parkland. I mean, he has worked on some big cases. He knows what he's doing. Others are not emotionally involved. Good point, Diane. Moscow
is, in fact, and you can't. When people are emotionally involved, there's no breaking that. There's not, and it's so hard to get past that level of investment in an outcome. Once people have told others that they believe something, and they're going to feel silly if they change their mind,
right?
And they've felt that emotional attachment to that outcome.
Yep.
It's just not worth it. You can't argue with them. You can't do anything about it. It's just, that's it. It's over.
Yeah.
And they can say that they're not going to be biased, but they are. They just are. It's just it. Now, put another way, less than a third of Latah County survey respondents reported following the case very closely. I would argue that whether you don't have to follow the case very closely to be biased.
No, absolutely. And the key, if going back to the original motion for change of venue, Ann Taylor brought up the fact that there's going to be, they are prejudiced by out of court statements, and the problem and so this has got to be all around them. Everywhere they go, they're going to see that university. It's a big physical campus. They're going to drive past Corner Club, or they're going to go past, I mean, I wasn't there until recently, reminders, and they're going to be talking about it over coffee or when they get together with neighbors, because this is right in their community. They're not going to know, Hella, if what they heard is something out of court or if it's in court. That's one of the issues that Ann Taylor brought up. That you can't voir dire that. They're going to be in that jury room, and they're going to think of something in their mind, and they're going to think it's a truth, like you said. And but they have to limit themselves to what they hear in the courtroom, the testimony, the documents, the evidence. But if it's so ingrained, and it has been for 2 or 3 years, by the time the trial comes around, who knows what's going to be in their head at that point.
Yes. Now, this has been a big deal. And someone on Twitter pointed this out yesterday.
Mm-hmm.
So this is straight from the state. Hang on a minute. Let me take Diane's note down here.
Oh, yes. This is huge.
Oh, this is huge.
This is huge.
Wow.
Another.
Okay.
Well,
another one.
Go ahead. I'm
being
tell
taken back by the
$1
state.
million question right here. Here's the state. Right?
Yep. So the probable cause affidavit did not explicitly state that the defendant was near the actual home of the victims, but stated that defendant was in the vicinity of a cell tower servicing the area of the victim's residence 12 times in the months before the homicides. Well,
this is information to Brett Payne, because he made it. Didn't he make it sound like he was driving past that house? And Mr. Gonzalez, didn't he say in one interview, and I realize this isn't from a court document, but that at one point he touched the internet at 11:22. Brett Payne
touched the internet.
Yeah, touched, like he drove past, and so he picked up the internet from 11:22. This is Bryan Kohberger. Brett Payne made it absolutely, just like he made it seem like Bryan Kohberger was stalking these victims. He made it sound like he was doing surveillance. He was going past this house. He did not one time state that the cell tower has coverage and it's something like 5 miles. One of the times that they said that he was in the vicinity of this house was when he got stopped in August of 2022 by the Latah County Sheriff, and that was way over, where all the shopping is, Office Depot, the old Bed Bath & Beyond. That is nowhere near. It's like something like 4.9 miles away. In the shopping area, they say the shopping's better in Moscow. People from Pullman will go over to Moscow to shop, and there's
restaurants. Apparently there's a particular kebab or gyro shop or something that Bryan Kohberger liked. Like there was a few restaurants that he frequented in that area, and as people do, because it's a university town. Of course there's shops and things like that the uni students go to. Why wouldn't he? It's not that far.
No, it's not. And the thing is too that there are a lot. They have a large, they have Walmart, and they have Office Depot, and they have Bed Bath & Beyond. It's closed now, but they have the big shopping place that you don't have that in Pullman. So there was, some people, the shopping is better in Moscow. So people will leave Pullman, Washington State, go over the state line and shop in that area. No vegan likes it. Oh, the mad.
No, okay. I think it's a gyro shop. Those. I'm sure they have vegan options, but people have been talking about him going to this shop. So I didn't make it up. I might be wrong.
He was going to the Mad Greek, and he saw. Even when
Mad Greek, that's it. Mad Greek.
She said the owner of the Mad Greek said he was never in here, but the rumors he went in, and that's where Maddie and Xana worked. They worked there. He was scoping them out, and he's driving past their house 12 times. He's stalking them. He's following them on Instagram. He's doing all this stuff. Nonsense.
See, now I'm repeating rumors, because that's the thing. I don't follow the whole what Maddie and all that were doing. I'm sticking completely to Bryan.
Right.
As far as I'm concerned, this is about there not being enough proof against Bryan.
You're right.
So, and that's just been my focus the entire time. IDAHO versus Bryan Kohberger, and I know there are a lot of side stories and rabbit holes you can go down with this case, and it's just not been my interest so far. I don't wish to spread misinformation or rumors about Kohberger, especially that he was involved with them, because I know he wasn't.
No, we've had the prosecutor stand up in open court and say, you know, Dr. Edelman, that there's no evidence that he was stalking them. Or, I mean, when this case first came out, these were the rumors that were out there, you know, with the Stephen Alva saying that he drove past and he touched the internet for 11:22, or that he was going into Mad Greek. I think that was from a People magazine article where he was going there. But these are the things that the people in Moscow are going to hear and not know if it's evidence that they were presented in the courtroom or if it wasn't. That's what Ann Taylor was arguing in that original motion. It's
exactly
point. Hell, it's a valid point.
All these facts and misinformation, they just get jumbled up to a point where people don't know what's right and what's wrong, what's coming from the state, what's coming from the defense. There's no line between rumor and innuendo, fact. And actually, it's interesting when I think it was about mid-May, end of May. Actually, yeah, mid-May. The state wanted to start closing off the hearings.
Oh, yes.
So, and it was a really turning point in the case, because they were starting to say things like, let's close off the hearings. There's too much media coverage, too much this, too much that. And it was one of those moments when I think it might have actually been, yes, it was the time that Anne stood up and said, the public needs to know what's happening here.
Well, that's right.
And then he questioned whether Bryan is innocent, because Bryan is innocent.
Right.
And yeah, exactly. And so much has been put out there. There's so much information, yet so little. And it's funny that people think that the defense is trying to hide something. No, it's the state that's trying to hide things. And it's just now. It was around the time when Cyril was about to testify for the second time. Where he'd come on board. The alibi was becoming more solid, and more solid as far as those who were interested in hearing the facts about it.
Right.
And and things were getting more interesting as far as public opinion beginning to turn against the state's narrative. And that was when she really fought for these hearings to continue to be public. And imagine if she hadn't won that motion, and at this point in time, everything was just happening in private.
Yeah.
It's so important that we're seeing what's going on.
At least that you raise a good point, because there was a motion to remove cameras in the courtroom, and Judge was concerned about the negative publicity that was out there against him. So I'm kind of hoping that he'll hold respect to this motion right here for change of venue. But so I just covered a couple of weeks ago, the motion to dismiss the grand jury indictment. There were two. One was on prosecutorial misconduct. The other was improper jury instructions, and the state wanted everything sealed. And she came out and said I think it was a January 11th, 2020 form. She says the public has a right to know what is going on in this case. Unfortunately, that was a closed hearing. I would have liked to know this exculpatory evidence that they kept from the grand jury. The defense has given us some kernels of information, like Jay one time at that hearing, it was an open hearing, there was a closed hearing. Do you recall when he said, well, some of the grand jurors, they wanted to see additional information about it. The judge said, well, you shouldn't talk, because he was talking in the open hearing, the second motion dismissed in the afternoon, information that came out in the morning, which was closed. And judge warned him, you got to be careful. So it was like Jay gives you a little bit of kernels, of information. Yeah. Sometimes they're trying to get it out there.
Okay. So let's get to, after all this garbage about his response to the survey, there's some stuff about how difficult it's going to be to get there. The trial does not need to find jurors that are entirely ignorant. Yeah, we know all that. The court can fashion remedial measures for the jury selection short of changing venue.
Can't be done.
So then he starts to talk about bringing jurors in from somewhere else.
Right.
Because it's all too difficult, moving everybody around.
Well, and sometimes that's what courts will, but I mean, you don't bring them in from the next county over. You bring them in from, from across the state, because bringing somebody in next door to Latah County isn't going to do anybody any good, because they're going to hear about it. They're probably also going to work for University of Idaho, or maybe, go to University of Idaho if they're the next county over. You need a jury pool from way, way across the state, or the trial needs to go across the state.
Yeah, because he's talking about impaneling a jury from a neighboring county.
No.
So, yeah.
What's that going to do?
Transferring venue would be convenient for the parties and witnesses, would not be convenient for the parties and witnesses, nor would it be in the interest of justice. How? Defendant next argues that the court should change venue. Yeah, how? First defendant argues that Ada County's large population size has more than 10 times as many potential jurors. Yes. Opposite larger jury pool to choose from. Yes. But the fact that Latah County is smaller than Ada County does not mean that it's too small to select a jury. It does.
Wrong. Yeah, I agree with you. I mean, you're one of your listeners has said 21,000 people. That is a small jury for a trial of this magnitude. That's a small pool.
Well, you and I were talking on message the other day, and you were stating that you think that this is going to go on for much longer than 8 weeks.
Oh my gosh. Yes. I mean, we were talking, I think we were talking about the OJ trial. I pointed out was only supposed to be 8 weeks. It went 9 months. Look at how thorough Ann Taylor is. I mean, this trial is not, I don't see it ending in 8 weeks. I think it's going to go much longer, which means then schools are going to be back in session. They're going to have the traffic issues. My husband put a cop out there. I mean, what's the big deal with traffic? You just put a couple cops out there and, have one of the Moscow Police Department out there and they can do traffic patrol or whatever.
Okay, so imagine that, right? Imagine if it went for a couple of months, like if it went for, say, 4 months instead of 2 months, and you had jurors that were then committed to being in this thing for way longer than anyone ever expected.
Exactly.
Yeah. Okay. So if you haven't changed venue and you're doing it in the middle of a university town, yeah, you're screwed.
Absolutely. I mean, and this is Bill Thompson's own argument. Here's a stupid argument right here. If elected sheriff, they were saying that, Chief Fry is running for sheriff and there would be a conflict of interest. And so
yeah, I saw that.
With Thompson saying his ingenious role, he could just delegate his duties to the assistant sheriff. Who does the assistant sheriff report to? The organizational, it goes him, exactly. That means nothing.
Yeah.
So now we have the clerk of court, who's Mrs. Fry, and possibly the sheriff, who is Mr. Fry.
It's also strange to state that the surveyor did not do polling in geographically closer counties such as Nez Perce County, given how close.
You want to move far away from Moscow. You want to get away from being in driving distance to Moscow, because the prejudice is going to be in Moscow. But as your next county over, you're going to have people that are going to be going to the University of Idaho. They know people. You have to go. But this is, I think, his naivety. He just doesn't understand how this process works. And perhaps if he had an expert, would be able to explain it to him a little bit better.
I think there's also a little bit of his own self-interest going on here. He doesn't want to have to travel.
Oh, 100%. I believe
Yep.
he wants to go home every night, and who wouldn't? Want to sleep in your bed.
Yeah.
He wants to be
Yeah.
able to play. I mean, I understand he plays guitar or something in some band. He wants to be able to play with his band on the weekend. But the focus here should be, as he raises time and time again with his misnumbered reasons, Bryan right to a fair trial. That supersedes everything.
It does. And okay, so I'm so interested in how Judge will go with this, because I don't see him as astute as someone like Judge Boyce, for example.
Mm-hmm.
I feel this Judge, I feel like he's a little bit of a Homer Simpson kind of character. Like he's kind of just there, just like, oh, you want me to sign that? Should I sign it now? Oh, okay.
But there's times when he's sort of surprised me. Like he could have very easily denied that IgG evidence. Oh, this is too hard to understand. This has nothing to do with anything. By the way, it does say here in the affidavit of probable cause we're not relying on the knife. Well, then why'd you put it in there? Why is it in there if you're not relying on it? But he did. I mean, I know we were talking about he knows more than the defense does. Because of the in-camera inspection. The defense, I think, should have gotten everything. Maybe, and I mean, their concerns were the fact that the state of Idaho persuaded him that the people that were on that family tree were informants, not in the traditional sense of informants, but they were informants. Why couldn't he have just X'd out their names? There's redacted information that you can mix things up so they wouldn't know who the identities are of who the people on this family tree is. But it seems, so he did get that. I like the idea that he didn't kick the cameras out altogether. Like he kicked the media out, but we still have
that was a boss move when he did that.
Yes.
I was very pleased when he did that. I wish he'd do something with the camera setup, but
I know. The only person you can see in that camera setup is Judge. That's the only person on the Judge YouTube channel that you can see.
Yeah, it's like, it's my channel, X.
Yeah, he had said he wanted wide shots. We got a wide shot now that's like,
we certainly have a wide shot. We do. It's just, I wish he would like just get his clerk or whatever it is to just do something with the audio visual. But he was a boss when he did that. So I really appreciated that move. So yeah, the networks would not play ball. They pushed it, they effed around, they found out. And he could have just gone, nah, no cameras at all. But in the interest of transparency, he knew that it was important that people saw what was going on and they cared. And so he made sure that we could at least hear it.
Yes.
The most important thing is that you can hear it.
You can hear it and you can see Judge. I mean, he is the only person that you can see, on the Judge YouTube channel, but you're right. Yeah. We still
we can see the witnesses. We can see the witnesses, okay.
We saw Brett Payne. Who expected him? When she said, I am calling Brett Payne, my jaw dropped. I did.
I know, right? That was good.
See him on the stand. How do you think he came across?
Oh, like a deer in headlights. It was great.
Big difference between Cy Ray and Brett Payne, huh?
Oh, how good Cy Ray. I am such a Cy Ray fan. I love him.
He was really, and I love how he said also, and this is a hallmark of a good expert, I leave open my opinion in the event that when they finally turn over this evidence, I may, it's subject to change. And that's how it has to be. That's how it has to be.
It has to be. It's like, if you want to show me something that changes my mind, go for your life. But you ain't giving me anything yet, mate.
Right. Because he understands his reputation means everything. He's not going to say something. So when I saw that that he joined the team, I said, this is going to be good.
That's it. It's on.
And he came across really strong on the stand, and that's what you need. You need confident, strong people versus the two Moscow Police Department police officers.
Maori
To me just seemed very incompetent with what did he have, like 3 weeks of training or something?
It's like, I use window snipping tool.
Window snipping tool. That was a classic. Oh, and when Brett Payne talked, oh yeah, I have access to experts. I'm like, yeah, Maori's his expert with his 3 weeks of courses that he took online or whatever he did. So this complicated.
And I loved it when Cyril actually commented on whether they were competent or not. I was like, burn.
No, he was very, very good. He came across real good. What do you think of the alibi? What do you think of the alibi defense?
Well, I mean, the alibi is what's going to exonerate him. So, and I think Cyril knows exactly where he was.
Yeah.
I think there's absolutely no question that Cyril knows where he was. I don't know whether he actually has the information that he's able to put forth in court without the FBI actually copying up that cast data.
Yeah.
So I don't know what he has access to legally, let's say. I don't know whether or not they've been able to subpoena the companies that they need to in order to get the data for him to be able to put into the software that the FBI has so that he can do the modeling that he needs to do in order to be able to put that forth in court, let's say, right? But I think that he's done it and he can show, well, he knows for sure himself where that phone was between 2 a.m. and 4 a.m. And he's shown, he knows. And he's shown Ann Taylor and Eliza, etc. And that's why ever since he's come on board, they have gone and said publicly, hey, Bryan's innocent.
Right. And people say, oh, defense attorneys do not say that. They do not
say that, especially not public defenders.
Right. No, they don't say that. No. They know. And I mean, that's, they started to, they're like, we're here, we're trying, we have to save his life. And when Jay that one time, he got a little teary eyed, I think that they realize that not only have they don't have evidence beyond a reasonable doubt. That is such a high evidentiary standard that they have to meet. But they're saying he's actually innocent of this.
Innocent, yeah. And they used the term in his alibi document, the one from April.
Right.
The motion putting forth his alibi, they said that he will be exonerated. They used the word exonerated.
True. And there was some rumor, it's not in any of the documents, but when he was in Monroe County, that he wanted to come back. He didn't fight extradition. People are not remembering. He did not. He could have very easily tied this up for a year by fighting extradition. And who knows if a judge in Pennsylvania would have looked at that affidavit of probable cause and said, does he have enough? I mean, what is this? Timeline of 4 to 4:25, but suspect vehicle 1 is seen speeding out of the neighborhood at 4. It boggles the mind. But he went back voluntarily. My concern is there's still a motion to knock that alibi defense out. The prosecution wants it feels that it doesn't have enough specificity, because under the statute you're supposed to show where you were and who could corroborate. In other words, I didn't do the crime because I'm in the hospital with a broken leg and my doctors can corroborate that. He's driving alone by himself. Who's supposed to corroborate him? He's saying she believes it can come out for cross-examination. Which witness, though, is going to be able to substantiate? Because she's saying through testimony, which is Cyril, I believe, and then through the defense, the prosecution's own witnesses. We'll see.
Well, okay. Here's something I need explained to me. it's to do with discovery, and there's a motion to compel for this cast data. It's been out there for a long time. If it does not get handed over, how can the state use any of it? So any of the cell data at all. So you can't have your cake and eat it too, right?
100%. I mean, they should have automatically turned this over. It was one of the, you look at the affidavit, and as much as he wants to say, oh, it's not relevant at this point, guess who signed the criminal complaint 12/29/22? It was Bill Thompson, based on an affidavit of probable cause. Bryan Kohberger would have never been arrested without that affidavit of probable cause being presented to Judge Marshall through Bill Thompson. The CAS data is all over that affidavit of probable cause. It is. And so remember when Ann Taylor stood up and said, I still don't know how they got to my client? That they can't use that. If they don't have it, they can't use it against him. I mean,
they can't, and their case is built on it.
Discovery evidence, right? Discovery. She wants the evidence that they have in their possession that will help her build a defense for her client. And again, there were three things that got him arrested: that knife sheath, suspect vehicle 1 belonging to him supposedly, and they have to turn it over. They have to.
They have to turn it over. So if they don't turn it over, then they can't use any of it. So they have to throw out everything to do with the phone.
Well, then that's what's called a motion in limine. You know, when the state asked for a scheduling order and Judge recently instituted it, one of the things that you're going to see under the pre-trial motions that need to be entertained before trial is a motion in limine. And so one of the things would be, okay, we don't have any of this evidence. You said it's all over the PCA. It is what got my client arrested, and yet you have not turned this over in discovery. They need to be sanctioned. They need to be prohibited from mentioning anything about CAST if they can't turn over the discovery to them. Period. End. Yes. Period. End of discussion.
Exactly. So hang on a minute. The discovery deadline is September, right?
September of 20, according to this pre-trial, the scheduling order he put in, yes, it's September, and then there's going to be pre-trial motions that need to be heard. So she can get up and say, as a discovery sanction judge, here it is. Here's the first supplemental request for discovery where we ask the third, the fourth, the motion to compel. They don't have it. It's like remember when Bill Thompson stood up? Remember when Bill Thompson stood up in open court and he was saying that he didn't have the IGG, the investigative genealogy tree, and all that information. It was in the possession of the FBI. I don't have it. It's like, well, tough. Who brought the FBI in? It's sort of like you outsource this investigation to this agency. You're responsible, and if you can't turn it over, then you can't use any of that. That was the bottom line.
Oh, also, Oline Red and Oline Red's. Thank you for joining us. She's awesome. Sadly, they will turn it over as late as possible, and the judge will let it in. It's wrong, but it happens all the time. Massachusetts did give the hair DNA to Karen until a week before the trial. It came in. Also, Oline, was it you who was saying that they used the TUI rule in Karen Reid as well? Because they cited the TUI rule. The feds have used the TUI rule as an excuse here too, in regard to the CAST data. I believe they're trying to use that to stop the request to bring it in, or the motion to compel to bring it in, parts of it anyway. So that's not good.
No, it's how did you? Okay, there's a path that led them to Bryan Kohberger, and part of it is the CAST data supposedly. How is it possible that he can prepare his defense if he does not have that discovery? It is not. I believe that what your viewer was saying here is true. Especially this judge. Thompson should have been sanctioned many times because she should not have to go, Ann Taylor should not have to go with a first, a second, a third, a fourth, a fifth, a sixth supplemental request for discovery and then file a motion to compel. She's being prejudiced now. His right to a speedy trial, he waived because he wasn't getting the discovery. How was she supposed to defend him at a trial without having the evidence that the state had in its possession against him? That would have been malpractice, absolute malpractice.
Online says it was used, but a lot of the FBI information came in anyway because the feds gave it up. It's how the defense got the ARCA guys.
Okay.
Interesting. So I just feel like they are trying everything to avoid giving this information over. Andrea Burkett mentioned that the feds have just disappeared from the Kohberger case. They have just like they helped out with the PCA, like they helped get that information so that they could get Kohberger in this situation. And since then, they've just been like, bye.
Why do you think? Well, I didn't hear Andrea's, and I agree with you. I really enjoy her perspective. Why did they abandon, in her opinion, this case?
Why do you think they've abandoned the case? Probably because it's not going very well.
Mess, because it's a mess, right?
Maybe there's a lot of exculpatory information in there that they don't want anything to do with. Perhaps.
They realize that there's an old saying: when you're not transparent and you're hiding things, there's usually a reason, and it's never a good one.
Yeah, exactly.
Where's the 911 call? Where's the 911 call transcript? Where is the video of suspect vehicle 1? Where's a photograph of Bryan Kohberger walking into the house? Where is all of this stuff?
Okay. Yeah, and there's so much against him, as people keep saying, where is it? Why are you hiding it? Like
this mountain
give it up.
evidence. Oh my goodness. How many times did we hear people say, oh, but the PCA is just 2% of what they have? It's like, how do you know what they have? How do you tell me 3 things that they have? They can't answer that because they have nothing.
Oh, but the DNA and people keep saying, oh, the DNA on the weapon. What weapon? There's no weapon.
Yeah, there's no
weapon.
There's a sheath that Jay Logson says was placed on Madison Mogen's bed. Yes, we understand that, but that's not a murder weapon.
The one that he dramatically dropped. It was such a mask and clothing, and it's just like, oops. And then he walked by and said, "Don't worry, I'll help you." With his bushy eyebrows.
Yeah. Oh, and you bring up a good point too. In the PCA, where yes, of course, the DM identification that the guy had bushy eyebrows. Do you know who identified Bryan Kohberger's eyebrows as being the eyebrows that DM saw? Was Detective Brett Payne. What he did.
Really?
Shade of the PCA. Go back and read the PCA. You will see what he did is he pulled Bryan's driver's license from Pennsylvania, where it had his photograph. He has bushy eyebrows. Like, since when does a detective? Number one, he changed the testimony that DM gave that it wasn't Kaylee, it might have been Xana who said there's someone here. Then what he says is, looking at his driver's license, he appears to have bushy eyebrows. That should have been DM saying, those were the eyebrows I saw, not the bushy eyebrows that we saw in Banfield, which were a set of the eyebrows, if you're asking me, right? Because bushy eyebrows to DM could have been something entirely different than what Brett Payne thinks they are. But it's like,
that's fair. Like, why would the victim or the witness not be the one who is going to be identifying it? That's silly.
You throw down, they do it. They do it all the time. They throw down 5 or 6 pictures. DM, okay, DM, here's 5 or 6 pictures here. Does this look like the person? And the person has half the face is covered. The bushy eyebrows, 5'10" or larger. How many people does that fit? 5'10" or larger, athletic builds, not muscular. How is she going to be able to identify him in a court of law?
What man doesn't have bushy eyebrows? He's not a man without bushy eyebrows.
Yes.
No man.
Seen some
You've got bushy eyebrows, CH.
class.
Guilty.
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 But it was Detective Payne who said, yes, Bryan Kohberger has bushy eyebrows based on the driver's license that he saw. You know that in the documents that we found that there's no body cam from Pennsylvania when they went in and they arrested him and they took possession of suspect vehicle 1 and all of his things. Very suspect to me. Secondly, Brett Payne spoke with Bryan Kohberger. That is absolutely a fact. It's in the court papers. So it's, when did he speak with him? Was it pre-arrest? Did he have an opportunity to speak with him for a couple of minutes when he was in the car being transported to the Monroe County Jail? That's an unanswered question at this point.
I would hope that Bryan would be smart enough not to talk, but who knows?
He spoke with Brett Payne, interviewed Mr. Kohberger. We just don't know when. It is absolute fact in the court documents. So I've always been curious, when did he speak with him? Under what? Some people say he was the DoorDash driver. Some people say, was it because he came forward and said, I made the delivery, or was it something, did Bryan come forward and say, hey, I can help you with this stuff? Or did Brett Payne approach Bryan? But it is an absolute
recorded.
It wasn't recorded.
Wasn't recorded. Who knows? Who knows? We don't know anything.
Yeah, everything is under seal. It is just that is the biggest issue that I have with this case. As you go through the documents, you start to see just the phenomenal amount of information.
So many.
The docket.
All right, we're going to have to finish up. This has been amazing. Thank you so much. I can't wait to have you back on the channel for this, maybe for Sarah Boone, for some fun.
Here you go.
It'd be amazing. This has been great, Kathy. You are just a pleasure.
I enjoyed it. I enjoyed the input from your viewers. I really appreciate having the opportunity to speak with you, and I would love to speak with you again down the line.
Yeah, it'd be amazing. All right, everyone, thank Kathy, and make sure you are on her podcast. It is pinned to the top of chat. So that is the Amazon link. I think that's probably the one that you like the most, but you can also be on listen on Spotify and things like that if you prefer. Kathy, you're amazing, and all of your podcasts are less than 5 minutes. So if you just want to chuck one on and get up to date with one of the documents, or if you want to just keep it on shuffle, that's awesome too. Your voice is very soothing. I love hearing your voice. You've got a great accent.
Oh, thank you.
And yeah,
I'm from Pennsylvania. Kohberger.
All right, let's keep in touch and make sure that we do another one soon. I will keep these discussions coming probably once a week or so. And also, those of you who aren't aware, I'm covering the Sarah Boone stuff. Usually they're at 7 p.m. Eastern whenever there's a hearing day. So make sure that you subscribe and that you keep your notification bells on for that one. And on the weekend, I have a very special stream about a attorney in Florida, actually, who has been the victim of cancel culture. He's a great friend of mine, Steve Gosney, and I'm going to be telling the true story about what's happened with him. Wow. So anyone who has been wondering about where he's gone and what is the reasoning behind that, he has recently left the state attorney's office. He was a very high-ranking public defender, but he left and went to train state attorneys to be more ethical. But then he's had to leave, unfortunately. So cancel culture is not a thing I like very much at all. So I'm going to be I'm researching this so I get all my facts straight, And so I can put something out there that does him justice. He's the most wonderful person, kind, and all you guys who know him in my chat and around the place on YouTube would be aware that he's just a great guy, wonderful author, and very much against the death penalty. So he advocates for that as well. So yeah, that will be Saturday, 8 p.m. Eastern. So put your notification bells on for that one too. All right, that's about it. I need to go and do some things for my little girl this afternoon. You guys have a good evening. Thank you again to Kathy. And I'm going to play my outro music.
Okay.
Bye. Awesome. Bye-bye. Ready, guys? Ready? Hey, there we go.
She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Donnie and she dances sometimes. The words are always so loud and because she's an 803. To the attention, excited utterance. Her cat is staring through